French real estate foreclosure, saisie immobilière, is a formal, judge-driven process that unfolds on a strict timeline. In practice, many cases stumble on procedural defects, valuation gaps, communication failures, and distribution mistakes. This condensed video highlights 6 frequent pitfalls and how to anticipate them from both the creditor's and the debtor's perspective. Let's begin with the big picture, because most pitfalls come from missing a deadline or a mandatory formality. From the enforceable title and the commandement de payer valant saisie, to the audience d'orientation before the enforcement judge, then publication at the land registry, marketing of the property, and the judicial auction. Each step has mandatory content and strict timing. This hearing is decisive because the judge validates the foreclosure route, judicial auction versus possible amicable sale, fixes key dates, and may rule on preliminary challenges. Issues raised too late are often deemed waived, locking parties into an unfavorable path. Allowing a statutory time limit to lapse, missing the window to contest the enforceable title or service, or failing to publish on time, can derail the entire procedure and force an expensive restart. Before pushing forward, make sure the legal basis is bulletproof, or the debtor will attack it at the first hearing. If the notarial deed or judgment is incomplete, insufficiently reasoned, not yet final, or improperly served, the debtor may seek a stay or nullity. Creditors must secure an impeccably enforceable instrument and an updated statement of debt. Mortgage rank matters a lot because distribution follows the order of inscriptions. A misread rank, a lapsed registration, or an unnoticed prior lien alters who gets paid first and may trigger litigation at the distribution stage. The answer is yes. Claiming amounts beyond what the inscription secures, or miscomputing interest periods and caps, can prompt rank challenges and materially reduce recovery. Many foreclosures fail on basic notice rules. Who was served, when, and with what content? Using the wrong address, omitting mandatory mentions, or failing to serve all co-owners or a spouse when required are classic defects. Any irregularity that impairs the debtor's defense can lead to annulment of key acts. Common motions include requests for grace periods, challenges to disproportionate clauses, or applications for a court-supervised amicable sale on a realistic timetable. Creditors should prepare evidence of urgency, deterioration risks, and marketability to resist these motions. The answer is yes. A brief standstill or an amicable sale under the judge's supervision can maximize value and reduce challenges, provided milestones are credible and tightly monitored. Price issues are frequent. A poor valuation or weak marketing can backfire at the auction. Relying on outdated comparables, ignoring occupancy or physical defects, or failing to document recent capex all depress value. A robust dossier, photos, diagnostics, leases, maintenance, helps avoid an artificially low reserve price. Insufficient publicity or confusing information reduces bidders. Conversely, clear conditions of sale, scheduled visit slots, and accessible data rooms increase competition and the hammer price. Late or incomplete bidding instructions to counsel, unclear funding proofs for bidders, and last-minute disputes over charges, easements, or co-ownership rules that should have been clarified in advance. After the hammer falls comes another battlefield. Who gets paid in which order and on what basis? Disputes usually arise at distribution with verification of claims, interest calculations, rank of inscriptions, challenges by preferential creditors, tax employees, and objections from co-owners. These are frequent flashpoints that can delay payments. By filing complete, up-to-date statements, proving continuity of their inscription, and checking for assignments or subrogations that may have altered priority. Early diligence reduces late-stage surprises. Incorrect interest accruals, ineligible fees, or double counting can unjustifiably inflate distributions. Scrutinizing the draft distribution can reduce the payout and sometimes justify a formal challenge. Even after a successful auction, practical hurdles can erode value if not anticipated. Identify occupants early, verify lease enforceability, and plan the timeline for vacating or continuing the lease. Ignoring occupancy realities delays handover and reduces realized value. Unpaid co-ownership charges, utilities, local taxes, and remediation duties may surface post-sale. Allocating these correctly in the conditions of sale prevents disputes after the auction. Clear minutes of proceedings, a complete dossier of diagnostics and easements, proof of notifications, and a precise breakdown of proceeds and costs provide closure and reduce the scope for later challenges. Foreclosure in France is unforgiving on timing and form. Defects in title, service, valuation, or distribution can undo months of work. Plan the timeline from day one, document valuation and publicity, and prepare both enforcement and negotiation scenarios. This approach protects creditors' recovery while preserving the debtor's legitimate protections.